How did you find your way to financial services?
I was mainly doing antitrust cases, but the head of our group worked a lot with DeKalb Research at the time, the seed company, who had a subsidiary named Heinold Commodities. And they had a lot of work they needed done in terms of essentially debit collection for the most part, because these were the early days of the industry when risk management was nearly not as good as what it is now. And there were just and they had a large retail clientele. And so I got into it from there, and I really, became fascinated with it.
Were there any big issues in the financial space?
In terms of getting started, options were a big educational process because people did not understand options who were in the futures market. So, and I spent about I believe it was about a year and a half in-house at Heinold Commodities on loan from our law firm. And so that was the period when options came in and stock futures came in. And so it was an educational process for people to learn how to do it. One of the issues that came out of financial futures was during the savings and loan problem we had in this country, and this was probably the very late 80s. The savings and loans were allowed to invest in government treasuries, whereas they were not allowed to invest in other things, and they were deregulated to where they really had to make money. They couldn't just deposit it with somewhere else, and so they used the fact that treasury futures were treasury bills or treasury bonds to invest in the financials, and some of them were just terrible at hedging and balancing their books out and making sure that the hedges matched. And then when the bailout came, the government, the Resolution Trust Corporation, sued a number of brokerage firms, saying you allowed my savings and loan to invest in an account that was labeled a hedge account, but we think they were really speculating and not hedging, and therefore we should recover all the funds. I prevailed on in a couple of cases was that from a clearing broker standpoint, they don't know when somebody's hedging or speculating, because people, they can have long exposure, they can have short exposure, they can have short term, they can have long term, and the fact that they're going in and out of treasuries does not mean they're not hedging their books. And we had one jury trial and one arbitration, which we prevailed on that defense.
What was the London commodity options case about?
Even though we didn't have options on U.S. exchanges in the 70s, under the foreign futures rules, you could have options from other countries sold in the U.S. And that's what these were. These were actually written in London, and they were on various commodities, I think sugar, gold, what have you. And it was a class action. And so these were people that dealt with a single FCM. And so the FCM was sued for a disclosure issue concerning a fee, which was called a foreign service fee. And the foreign service fee was used as compensation for the broker in addition to the commission. The firm felt that it was properly disclosed. The plaintiffs disagreed. They say it wasn't properly disclosed, and therefore, that was fraudulent to label what was essentially compensation as a foreign service fee. And the real issue that took 16 years to litigate had to do with what would be the damages if they won. And they said we should get all our losses on the London commodity options because these were almost always unprofitable. They were just bare long call options generally that expired, worthless. And our position on the defense was, no, if you have a claim, it should be limited to the amount of the fee, because you don't say there was anything wrong. Nothing was misrepresented about the option itself. You don't claim any fraud in relation to the option itself. The only fraud you claim is that there was this fee that was charged that you didn't know what it was going to be used for. And it took, finally, we got it after, 14, 15 years of litigation, we finally got the Illinois Supreme Court to overrule the lower courts and say, yes, this is it's limited to the fee. And then it was able to be settled. But until that time, the parties were just too far apart. It would have been maybe $100 or something like that per option.
What was the confidential commodity swaps investigation?
That was a CFTC investigation relating to whether swaps were futures, basically. It really was very interesting because the way swaps were started in London, I would say around 1980, and they were pretty much exclusively currencies and interest rate swaps were the original swaps. And I think, and they got bigger, the market got bigger and bigger over the years. And I think the CFTC always took the view, probably without a whole lot of interest or study in the subject, that these were banking products. So that's not within our jurisdiction. And then in the mid 80s, some firms started wanting to trade swaps on actual physical commodities and started doing it because, again, it's a banking product, and the OCC, the Office of Controller of the Currency, actually wrote an opinion that these were banking products. And but the CFTC decided that, well, maybe these were futures contracts. And my understanding was they were getting some pressure from the exchanges, who saw this as a threat to their business. That the exchanges felt if the banks could offer swaps on commodities that were the equivalent of futures, the banks would get the big business, and people would just hedge the residual on the futures markets. And it didn't turn out that way when swaps got bigger and bigger. But in any event, it triggered an investigation to decide what are these? Are they really futures contracts, or are they something else? And how do they fit in on the law? And that went on for years. There was a lot of staff time put in. There was an off-exchange task force that was formed by the CFTC during that time. And eventually, Wendy Graham was appointed the head commissioner of the CFTC. And it was during her tenure that the CFTC came out with what was called the 1989 Swaps Policy Statement. And that set forth basically the guidelines by which an instrument could be considered a swap and not regulated as a futures contract, and those that would not. And that really settled the issue. It was later codified into law.
What was the alleged ginzy trading in 1989?
Essentially, a little bit of background on that. There was a case, a CFTC enforcement case, where they did find that people were through prearrangement trading a ginzy in the Treasury bond futures at the Board of Trade, and there were I think at least one trader, maybe two, probably at least one local and one broker and one or more locals that were actually fined for ginzy trading, one tick apart at the Board of Trade bond futures. Sometime later, within a year or two, the CFTC brought another case, which is the one I was involved in. And there was no evidence of prearrangement. There was no allegation of prearrangement. What would happen is the broker would come into the pit. He would either bid or offer whatever he wanted to do on behalf of his client a certain quantity of bond futures, and then he would do the same thing for the same quantity, one tick apart. And so, in effect, he would the trade looked at as a whole, the two trades looked at as a whole would be a half tick trade. And there were about 20 locals that would make markets for this broker. They were the ones that both the broker and the locals, an action was brought by the CFTC against them. But the difference between that and the original case was that there was no prearrangement. There was no evidence of prearrangement. What happened was he just established a pattern, essentially, by doing this each day, and they came to know to expect it. But there was no binding agreement, and so he could have backed out of it in the middle at any time. He was not committed once he did one part of it. He didn't have to do the other part of it. the broker. And the Board of Trade itself looked at it and decided not to take any action, but the CFTC wanted to take action, and they said it just the way the trade is structured is somehow non-competitive, even though there's no prearrangement. We actually had the Board of Trade General Counsel at the time, Scott Early, actually came and testified on behalf of the defendants at the CFTC proceeding to let the administrative law judge know that the Board of Trade had already looked at it and decided not to take any action. And the administrative law judge ended up ruling in favor of the locals and the broker on the ground that, without prearrangement, you could not call it a non-competitive trade, even though the result was half-tick trading, in effect.